Beautiful.
Morning, Philip.
Good morning.
I'm John Ross. I have to introduce you. I'm wondering, just to confirm, your last name is it Osterhout?
That's right. Yeah.
Perfect. I hate saying names incorrectly.
Hey, you know what? You're one of the few to get it right on your first try.
Thanks so much for doing this morning, Philip. This is we're excited about it, and I'm hoping it's very well received.
Oh, my pleasure. Yeah, no, it's been a busy year for new legislation, so I think it's helpful to touch base like this every now and then.
Yeah. We sent it. So I'm based in Haliburton, and we send invitations out to the 4 municipality planning departments and CBOs here, and I think 3 of them are jumping on, as well as the county planner. So we're pretty excited about that. So hopefully, hopefully they're able to gain a little bit of knowledge in this as well.
Great. Well, I'll try not to give them too many tips on how to stall or.
Just as long as you're willing to swoop in and make them not stall. That's my.
Well, I don't want it to be a make work seminar either.
We're going to be about an hour. Yeah, I think it's. I think we're set for an hour.
Yes, that's correct. That's correct.
Sounds about right to me.
Good morning.
Good morning.
Hey guys.
Thanks for joining us this morning, both you guys. We really appreciate your time.
Oh, it's our pleasure. I was having a little computer issue, but I got on, so that's good.
Perfect.
How is Philip and Chelsea this morning?
Good. How are you, Todd?
Oh, I'm hanging in there. I'm hanging in there. It's Monday morning, and I've already had 3 client emergencies, so it's a typical Monday. There you go.
Okay, John Ross and Glenn, we are ready to go.
Okay. Well, good morning, everyone. Thank you so much for joining us. This is the Eastern Region webinar on the land use legislation that's come through in the last little while. My name is Glenn Evans. I'm with the Halliburton Home Builders Association, past president and co-chair for Ontario Home Builders Eastern Region. I'd like to thank our sponsors this morning, Cambrian Consulting and Engineering, as well as Three Trees, with their help and everything on this. Much appreciated, as well as the local HBAs, Cornwall, Halliburton, Kingston, Lanark, Leeds, Peterborough, Kawartha, Greater Ottawa, and of course Quinte, and especially thanks to Ruth with all her work on this. I really appreciate it. We both do. With that, I'm going to turn it over to John Ross Parks, my co-chair at the Eastern Region, and he's going to introduce our panel today. And just one other little reminder before I go, we are welcoming questions throughout the webinar today. If you please use the question and answer feature on the Zoom thingy. What's the Zoom thingy? Anyway, thanks very much, and I'll turn it over to you, John Ross.
Thanks, Glenn. Hi, everybody. Welcome. Very exciting that we're able to do this with our Eastern Region partners. Hopefully, this will be the first of many more to come. And so thank you again, everybody, for coming. I'm John Ross Parks, past president of the Quinte Home Builders Association, current board director, is also Eastern Regional co-chair with Glenn. And so we're very excited to see you guys. We've got some fantastic panelists today. So first up, we have Todd Storms. He's the partner for construction law, and he's a commercial litigator. So Todd practices primarily in the areas of construction law and commercial litigation. For construction, he frequently advises owners, general contractors, subcontractors, governments, suppliers, and builders in contract review, procurement, tender issues, and other construction matters, as well as construction litigation, construction liens, and arbitration. As a commercial litigator, Todd's practice encompasses shareholder disputes, contract disputes, mortgage remedies, commercial tenancy issues, and bankruptcy and insolvency litigation. I don't think this guy sleeps. As mentioned, Todd is a commercial litigator. So Todd's appeared before all levels of court in Ontario, as well as appearing in the Maritimes, Quebec, Alberta, British Columbia. He's also appeared before a number of administrative tribunals, the Royal Commission, and committees of Parliament on behalf of clients. So Todd also is available to act as a mediator on commercial and construction disputes as well. We also have Philip Osterhout. He's an associate, joined Soloway Wright in 2015 and began practicing municipal and planning law immediately after his call to the bar in 2017. As an experienced associate in our municipal land and development expropriation group, he regularly represents developers, businesses, homeowners, and municipalities in navigating land use regulations and a full range of development approval. Philip enjoys collaborating with his clients' land use planners, architects, engineers, and other professionals to develop innovative solutions, working on all manner of Planning Act applications and reviews, development agreements, conservation authority matters, development charge issues, heritage properties and districts, and expropriations. He offers strategic insight that considers each client's unique circumstances and objectives. Much of his practice includes appeals before the Ontario Land Tribunal, which was formerly the Ontario Municipal Board and Land Planning Appeal Tribunal, much longer name. He also represents his clients before municipal councils and committees, including the Committee of Adjustment, the Planning Committee, and Building Heritage Committees, as well as the Ontario Court of Justice and the Ontario Divisional Court. Outside the office, hiking, canoeing, camping are among Phil's favorite hobbies to share with his beautiful and talented wife, who he says absolutely did not write this bio for him, and his delightful daughter. Lastly, we have Chelsea Packman. She's an associate. She joined Soloway Wright as an associate in 2022 after practicing civil litigation with a full-service Ottawa law firm. She's an associate in the construction law, commercial litigation, environmental, and employment law groups, and has appeared before the Superior Court of Justice and Small Claims Court. Chelsea graduated with a Juris Doctorate from the Schulich School of Law and Dalhousie University and holds an environmental science degree from the University of Ottawa. While at law school, Chelsea was actively involved in the East Coast Environmental Law Association and acted as a board member for the Not-for-Profit Association. Outside the office, you can find Chelsea spending time with her family and friends. Chelsea also enjoys trying new recipes, hiking, playing sports, and indulging her love of seeing new places. And with that, I will turn it over to Todd to take it away. Thank you very much.
Thank you, John Ross. I appreciate the introduction. I never know how to feel about those. I always feel like just want to say, here's some lawyers, and then let us talk. But I know introductions are good, so you get some more background. A couple things I'm going to say to the group first. What I've been working on. I'm going to let Philip go first, who's going to talk about legislation, and then I'm going to talk about the PPS a little bit at a high level. But what I've been working on, and I'm going to send to Ruth, I tried to get it done this weekend, but I just couldn't, was I've created what's called a concordance table for the PPS. So basically what that is I've taken the growth plan and all of the sections of it, and then married it up with the new proposed draft PPS so that you can see where to find all the old stuff in the new one, along with what's been changed and what hasn't. Okay, so it's a large undertaking. Like the table itself is like 12 pages. So I'm almost done. But what I'm going to do, just as a heads up to everybody, is once this is over, if you'd like that table, and keeping in mind that it could change, but if you'd like that table, I'm going to email it to Ruth hopefully tonight or tomorrow morning, and just or you can email me if you want, but I'm going to give it to Ruth so that it's available to membership and everybody here today. So if you contact Ruth, say by Tuesday evening, she'll have that table in her hands. And if you're interested in just seeing how at this stage the legislation marries up, you'll be able to see it there. So I just thought I'd put that out because I tried to have it done for today, but I couldn't make it. So Ruth will have that. So if that's of interest to you, please keep that in mind. Now, with that, I'm going to turn it over to Phil to give a quick talk, and then I'll jump in on the PPS and we'll take it from there.
Sure, thanks, Todd, and thank you everyone for joining us. I think it's important to get together and kind of do a bit of a state of the nation every now and then, especially this year. There's been a lot of legislative changes. As John Ross mentioned, as my wife mentioned in my bio, I do have the pleasure of being a new father, and my daughter was born April of 2022. Poor kid's only a year old, and she's already had to relearn the Planning Act 3 times. So this has kind of made everything a little bit frustrating, and I get the same sort of impression from my clients that every time I speak with them and say, look, that's no longer the way things are working, there's a bit of frustration at the moving process. The good news, I think, for many of the people joining us is a lot of these changes are intended to help developers and to make the process more efficient. But I've got a friend who's a land use planner who often says, I am an agent of change and people just don't like me. So there are going to be growing pains. And I think a lot of the inefficiencies that we're seeing are just from, one, people trying to find the ground under their feet and deal with all of the changes, because there have been a lot of them. And 2, the new requirements being imposed by the province are very demanding. They have made it very clear through the titles of the legislation alone that they really want to see a lot of new housing developed very quickly. And that puts a lot of strain on a system when you're trying to do things well. So we thought it would be helpful to start with a bit of a recap of the legislation, where we are over the past year. So there have been 3 significant changes to planning legislation over the last year. In April of 2022, we had Bill 109. The More Homes for Everyone Act was given royal assent. Then in November of 2022, we of course had Bill 23, which introduced significant changes to about 10 pieces of legislation through the More Homes Built Faster Act. And now just in June of 2023, we have Bill 97 received royal assent, which is the Helping Home Buyers Protecting Tenants Act. So Bill 109, I don't think I need to speak about too quickly in too much depth, but it introduced first, I think the first warning sign that planning application fees would be refunded in the event that they're not processed within the specified time limits. So I know many municipalities have been dealing with that over the course of the last year. How do you deal with that sort of time pressure? And as I'll come back to, Bill 987 has actually brought that into force as of July 1st, 2023. The second point I wanted to make with respect to Bill 109 before moving into the substance of Bill 23, and I only make this point because it still seems to be surprising to some people, but as of July 1st, 2022, all site plan control approval must be delegated to staff. So that's a fairly significant change for some municipalities. I know some are still dealing with it at committee and council level, but important to keep in mind that particularly as we start dealing with the new time pressures, everything to do with site plan control can and should be dealt with at a staff level. So Bill 23, certainly the most significant changes we saw in the past year, as I said, received royal assent in November 28th of 2022, and amends 10 pieces of legislation. I won't go through them all, but for the purposes of today, I'll speak briefly to the Conservation Authorities Act, the Development Charges Act, and the Planning Act. And I'll note, of course, this is certainly meant to be a high-level summary of really just the key changes that we've seen. But certainly if there are questions about any other provisions, we should have lots of time for that as well. So with respect to the Conservation Authorities Act, Bill 23 significantly reduced the scope of jurisdiction of some conservation authorities. In particular, it removed a conservation authority's ability to comment on planning applications. So that's important to keep in mind going forward as planning applications are reviewed. I know some municipalities are still collecting fees for that consultation, so that's something to be aware of. It is also important to note, however, that conservation authorities do retain the jurisdiction within their regulation limits. So for example, if you're doing any work within a regulated floodplain, you still require a permission from the conservation authority. And so there's an increased onus on landowners to do that review and make sure that you're getting all the approvals that you need, even though they're not necessarily being consulted on the planning application itself. The province is working on a standardized regulation for all conservation authorities, and that will replace the individual current regulations for each separate conservation authority. A draft has been published. I believe the comment period is now closed, but I'd encourage you all to review it, particularly if you're working in those areas. Moving to the Planning Act, there are, I think, 5 significant areas of amendment that I'll speak to. And the first, just in general, is that all moratoriums on applications under the Planning Act have been removed. So previously, anytime there was a new official plan or a comprehensive zoning bylaw amendment, the Planning Act imposed a 2-year moratorium on any applications to amend those provisions. Those have both been repealed. So now an application for official plan amendment can be filed at any time, regardless of how new the plan is. That's significant for some municipalities where, for example, in the city of Ottawa, there was a new official plan that came through, and the municipality was taking the position that any active official plan amendment application was therefore effectively dead because you were trying to amend an instrument that was no longer enforced, no longer existed. These provisions allow for those applications to be carried over and effectively transferred to the new official plan as approved. The maybe more significant moratorium that was removed is the prohibition against minor variances on provisions of a zoning bylaw amendment within 2 years. Those have been passed. So now there's an opportunity to bring a minor variance application regardless of how new a zoning provision is. And you could do that, one of 2 reasons. One, it may simply be an oversight in the application. Often zoning amendment applications are filed on conceptual plans, and as you get into the detailed design, you realize that some additional relief may be required. The second reason, though, is maybe for more strategic reasons, and that plays partially into the second big area of changes, that there is no longer any third-party right of appeal to Committee of Adjustment decisions under the Planning Act. So any minor variance application or consent where approval is granted, a third party other than prescribed, mostly utility companies, do not have any right of appeal to that decision. Third, the alternate rates for parkland dedication have been decreased. So under the Planning Act, of course, any residential development is subject to a standard rate of 5% of your parkland or value of your land. The municipality, however, can impose an alternate rate of 1 hectare of land for every 300 units. That has now been changed to 1 hectare of land for every 600 units. Or where cash in lieu is required, it's 1 hectare for every 500. After Bill 23, that's been increased to 1 hectare of land for every 1,000 units. So in each case, the amount of dedication is effectively half of what it could have previously been. There's also statutory caps that have been expanded to all land. So regardless of what your rate is, it can't exceed 10% of your total land area. Unless you have more than 5 hectares of land, then you're capped at 15% of the land area or 15% of the land value. Additional changes were also introduced on parkland that allow an owner the opportunity to identify certain lands that it wants to designate to municipalities. That will be done on the basis of prescribed criteria, and so those provisions are not yet enforced, but effectively there will be criteria established through the ministry through regulation that set out what types of land can be conveyed to the municipality for parkland, and then an opportunity for the municipality to decline that land and a right of appeal if necessary. The fourth significant area, site plan control. So site plan control under Bill 23 is now restricted to residential developments with 11 residential units or more. Under Bill 97, there's a slight walk back on that change where the minister can now prescribe by regulation certain areas where that exemption doesn't apply. No regulations have been passed to my knowledge. So until you hear otherwise, I think it's safe to assume that if your residential development has 10 or fewer units in it, you'll be exempt from site plan control. Under Bill 23, site plan also can no longer regulate any exterior design, with certain exceptions regarding design for affordable units. But when you file your application, there's still a requirement to file architectural elevations showing at least conceptual design. Along with that, site plan can't regulate any design regarding adjoining lands, such as the municipal right-of-way. Fifth, a fairly significant addition that came in through Bill 23 was the permission to have up to 3 residential units on any parcel of urban residential land. So this is a new definition that's introduced into the Planning Act that deals with any parcel of land that's on full municipal services within an urban boundary or settlement area, and 2 is zoned for residential use. In those areas on a parcel of urban residential land, a zoning bylaw is no longer effective at prohibiting the addition of a second or third residential unit. So effectively, if you're zoned for a single detached dwelling, you can now, as of right, introduce a second and a third unit into that building, or have 2 buildings with 2 units, 1 building with 2 units and a second coach house ancillary building. As part of those, the municipality cannot regulate through zoning a minimum size for any of the 3 units, and it can't impose any parking restrictions other than to require 1 parking space per unit. As part of Bill 97, some of those have been changed. So Now there's an opportunity to require more than one parking space for the primary unit, but still only one space for the second and third. Next, under the Development Charges Act, second and third residential units at the same time are exempt from development charges. Also worth noting, that the second and third residential units are exempt from parkland requirements. Under Bill 23, Development Charges Act also allows for discounts on residential housing developments. So where there are 4 or more residential units in a single development, all of which are being maintained as residential, as rental residential, development charges are discounted between 15 and 25% based on number of bedrooms. So if you have 1 bedroom unit, it's discounted 15%, 2 bedroom is 20%, 3 or more bedrooms get a 25% discount on applicable development charges. Where there is an existing residential rental development, you're entitled now to add 1% increase in units or 1 unit, whichever is greater, and those additional units are exempt from development charges. Another interesting exemption provision that's been added through Bill 23 is that any new development charge bylaw that's passed after January 1st, 2022 will be phased in over a 5-year period, starting with an 80% charge. So on the first year that a bylaw is passed, only 80% of the development charge is paid. In other words, there's a 20% discount on the standard rate. That discount is decreased by 5% each subsequent year. So in the second year, you pay 85% of the total charge, then 90, so on, over the course of 5 years. Along with that, of course, development charges bylaws are now good for 10 years rather than just 5. But it's worth noting that any existing DC bylaws may have expiry provisions built into them. Most DC bylaws are based on background studies that were planned over a 5-year horizon. And so many of them will include provisions that say this bylaw will expire at the end of 5 years, even though the DC Act now allows them to go up to 10 years. Moving next to Bill 97, I'll just give sort of 5 highlights coming out of this. First, the Municipal Act has been amended to include new regulatory powers that allow the minister to prescribe certain requirements for demolition control. And it can require municipalities to provide additional notice or prescribe criteria that need to be included in demolition control bylaws. Also can require that compensation be paid in the event that rental units are being removed. So nothing in force yet as of that, although the provision is there. So those regulations, I think, can be expected in the coming future. Second, there's new expanded appeal rights for interim control bylaws. So currently, or until recently, there was only the option to appeal an interim control bylaw after it was extended. Now there's an initial appeal right when the interim control bylaw is first passed. Third, there have been some housekeeping amendments to the provisions of the Planning Act and the DC Act dealing with 3 residential units. So as I said previously, under Bill 23, 3 residential units are permitted as of right on a parcel of urban residential land. The Planning Act also restricts appeal rights with respect to any additional provisions in an official plan or a zoning bylaw amendment that permit up to 3 units on any parcel of land. Those provisions previously didn't extend to coach houses. And so the implication of this new change is that if a municipality were to pass regulations either through its zoning bylaw or through the official plan, contemplating a coach house, 3rd residential unit in a coach house or any other ancillary building, for example, in a rural area, it's now entitled to do so and there's no right of appeal. Fourth, as I indicated, a municipality may now prescribe through a zoning bylaw parking restrictions requiring more than one parking space for a primary residential unit. It's still limited to one parking space for a second or third residential unit. And then the big change brought about by Bill 97 is the implementation of the return of planning fees where applications aren't processed within the specified timelines. So this was first introduced through Bill 109, although it hasn't come into force. So as of July 1st, 2023, any zoning bylaw application that is filed after July 1st, 2023, a decision must be made within 90 days. And if a decision is not made within 90 days, unless there's a concurrent official plan amendment, then the municipality is required to refund 50% of the application fee. If there's a concurrent official plan amendment, then the time limit is 120 days, because of course that's the amount of time to process an OPA under the Planning Act. If the specified time limit is exceeded by 60 days, then there's a 75% return of the application fee. And if the time limit is exceeded by 120 days, then the full application fee is refunded. Similarly, site plan applications are subject to the same format, except for the time limit to process them is 60 days. So any site plan application filed after July 1st, 2023 needs to be approved, not just decided, but approved within 60 days. If it's not approved within 60 days, the municipality needs to refund 50% of the application fee. If not approved within 90 days, it's 75%. And if not approved within 120 days, then the full application fee is refunded. And so one of the implications we're seeing from this too is a municipality no longer has the opportunity to decline to approve a site plan application without seeing a refund in development or in application fees. And none of those refunds are discretionary in any way. So with that, subject to any questions, I will throw things back over to Todd and he can talk a little bit about what he's seeing on the construction side of things.
Sure. Thanks, Phil. There's one question here from Glenn Evans, I believe it is. Sorry if I've got that wrong, but he's asking, is the 30-day appeal time following a committee of adjustment ruling still in place?
So there is still a right of appeal to certain prescribed public entities, and I believe the minister. It would only be someone who commented on the application. Where there is a refusal of a minor variance, for instance, there's still a right of appeal on behalf of the applicant. Where there's approval, I think technically you'd still be waiting about the appeal period, but you can safely assume that, you know, subject to any significant comments from someone who is entitled to appeal, that there won't be any challenge.
Okay. And also, Phil, this isn't a question. This is me imposing something upon you, if you don't mind. I'm going to suggest that maybe we take our speaking notes, the point form bullets, and could we circulate that to Ruth, just so that the attendees today, if they are so inclined, can ask Ruth, and then they can have like a summary of our speaking notes. I'll do the same. I'm already going to send her a concordance table, so that way all the attendants today can have that information. If you don't mind, I'm sorry to make more work for you, but if you don't mind, it'd be helpful.
Yeah, no problem.
Okay, great. So thanks, Phil. So look, I'm going to talk very briefly because we could talk about it forever about the provincial policy statement and growth plan, and then after that. Because you have Philip and I and Chelsea, I'm more than happy to talk about Construction Act stuff, anything you want, really. But it doesn't have to be stuck to the topics that we have today. But you have us in the room, so take advantage of it if you have any questions. But I want to talk about the provincial policy statement, and just because I'm you know, these proposals, and we'll talk about it a bit, affect the official plans for the municipality. So right now, I might have the dates wrong here, but I believe the city of Kingston is working off a consolidated plan dated from December 2022. I think Belleville's plan, which was approved, and I'm sorry if there's anybody in the room if I'm getting these dates wrong, I apologize, but I believe the city of Belleville's plan was approved way back in late 2021 at the municipal level, but only approved by the province in April of this year. And I know Quinte West adopted their official plan, I believe February of this year. So the changes that are being made or being proposed to be made by the provincial policy statement and growth plan are going to affect the official municipal plans, and obviously that affects the industry. So I'll just do a quick high level point by point here for those who may not know. So the new proposals for the PPS or provincial planning statement, I'll just call it PPS, proposes to take policies from the provincial policy statement of 2020 and combine them with the growth plan for the greater Horseshoe area, I believe it was called, or the growth plan as they call it, in an effort to achieve the provincial's housing objectives and balancing the need to protect the environment and agricultural lands. And I know some of the proposals in Prince Edward County have been objected to, or there's been councillors that have been vocal in Prince Edward County with respect to specifically trying to get the province to maybe reconsider some of the rural development issues in that, because they feel like it encourages sprawling as opposed to centralized development. But I'm not going to take every region because there's very different regional issues that we can get to individually if you wish, but that's just one example. So the new PPS is going to be considered a policy statement for the purposes of a planning act. So in accordance with the Planning Act, decisions of approval authorities would be required to be consistent with the new provincial policy statement. So I'm going to touch on three significant highlights. Okay, one, generate housing supply and make land available for development as number one. Number two is to provide infrastructure to support development. And three is balance housing with resources. So the first one, generating housing supply and make land available. So consistent with the province's direction to build 1.5 million homes, the new PPS includes policies that identify large and fast-growing municipalities to eliminate intensification targets and broaden the municipality's ability to expand settlement areas. Now, with respect to the attendees here today, the main municipality that this affects is Kingston. Kingston, there's a list of 29 municipalities. Kingston is on that list and considered a large and fast-growing municipality. So some of the points that are Kingston specific are they will be encouraged to plan for a minimum density target of 50 residents and jobs per hectare, will identify and focus growth and development in strategic growth areas, and will delineate the boundaries of major transit station areas on high order transit corridors through an official plan or an official plan amendment. Municipalities will no longer be required to plan for specific population and employment forecasts for an identified horizon year, which is currently the case in the present growth plan. And instead, municipalities will be expected to complete their own forecasts with a 2051 forecasting target set as a minimum. Additionally, municipalities will be required to have enough land designated for at least 25 years, whereas the current plan requires to have enough land designated for up to 25 years. So now it's going to be at least 25 years. With planning permitted to extend beyond this horizon for infrastructure, employment areas, and SGAs. The planning PPS 2020, the one that's about to be revised, housing policy requirements to maintain designated lands and available for residential growth for a minimum of 15 years and to maintain zone lands and servicing capacity sufficient to provide 3 years of supply for residential units are maintained. So again, an increase in the new plan. Also, there is now going to be the removal of municipal comprehensive review. So currently the growth plan contains various policies that generally only permit conversion of employment lands and the expansion of settlement areas through municipal comprehensive review. And the concept of municipal comprehensive review has been removed from the new PPS. And as a result, the conversion of employment lands to non-employment lands and the expansion of settlement areas will be able to occur at any time. Settlement areas and settlement area boundary expansion has been changed. So the policies relating to settlement areas and settlement area boundary expansion are proposed to be revised substantially. Under the new policies, a new settlement area or expansion may occur at any time, provided that planning authorities consider the following criteria. There is sufficient existing or planned capacity of infrastructure and public service facilities. The lands are not specifically or are not specialty crop areas. There is compliance with minimal distant separation formula. Any impacts on agricultural lands are minimized or mitigated. And whether there will be a phased progression of urban development. So those are the criteria for consideration. In addition, there will no longer be any prescribed density targets for new settlement areas. However, as I stated before, large and fast-growing municipalities will be encouraged to plan for a minimum density target of 50 residents and jobs per gross hectare. Other changes are the strategic growth areas. So strategic growth areas were previously introduced in the growth plan and include urban growth centers and other areas where growth or development will be focused. The new PPS would require large and fast-growing municipalities to identify SGAs and would permit other municipalities to do that as well, but at their discretion. This involves identifying an appropriate minimum density target and the appropriate type and scale of development for each SGA. A new policy is also proposed that would require any reduction in size or change of location of an urban growth center that is identified in an official plan as of the date to be announced to occur only by way of a new official plan. Let's see, I want to go, I want to also point out these two. I'm just trying to hit the high level ones that affect members. Increased residential development in urban areas, or rural areas, sorry. Currently, the PPS 2020 promotes development in rural areas that is compatible with the rural landscape, and it encourages the conservation of existing rural housing stock on rural lands. The new PPS proposes to remove these policies to facilitate more development on rural lands. In addition, the new PPS proposes to permit increased residential development on rural lands by permitting multi-lot residential development where the site conditions are suitable for the provision of appropriate sewage and water services. And the new PPS also proposes to modify the agricultural policies of the PPS 2020 to facilitate more residential development in prime agricultural areas. The new PPS would permit a principal dwelling associated with an agricultural operation with some limited exceptions, as well as up to 2 additional residential units provided the proposed units meet certain conditions, which are being proposed in the regulations. And in addition, the new PPS would introduce policies permitting residential lot creation in prime agricultural areas in accordance with specific conditions yet to be determined. Now, one of the other goals that is being proposed, obviously, is balancing housing with resources. So the new PPS talks about expanded housing options definition. So the new PPS would expand the definition of housing options to include laneway housing, garden suites, room housing, low and mid-rise apartments, additional needs housing, multi-generational housing, student housing, farm worker housing, culturally appropriate housing, supportive housing, community housing, and transitional housing. It also removes the affordable housing definition. So the new PPS proposes to remove the definition of affordable, which currently exists in both the PPS 2020 and the growth plan in the Greater Horseshoe. It also proposes to remove references to market-based and affordable housing in the new housing policies, as well as the current policy in the PPS 2020 that requires planning authorities to establish and implement minimum targets for the provision of housing which is affordable to low and moderate income households. Instead, the new PPS proposes a policy requirement planning authorities to coordinate land use planning and planning for housing with service managers to address the full range of housing options, including housing affordability needs. It allows for the conversion of existing commercial and institutional buildings for residential use. The new PPS proposes to add a policy that planning authorities shall provide for an appropriate range of mix of housing options and densities by, among other things, permitting and facilitating the conversion of existing commercial and institutional buildings for residential use, the introduction of new housing options with previously developed areas, and redevelopment, which results in a net increase in residential units. And the new PPS encourages, with respect to agriculture, planning authorities to enhance a geographically continuous agricultural land base, and maintains many of the PPS 2020 agricultural policies. However, it would no longer require municipalities to use provincially mapped agricultural system, but it would still encourage municipalities to use an agricultural system approach based on provincial guidance. It is unclear whether this guidance will be based on existing provincial map of the agricultural land base or other provincial guidance yet to be determined. So those are some high level changes to the PPS, and those are just like the very high level. When I give Ruth the table of concordance, if you want to get down into the minutia of it all, you'll see that there are well, just like at least 60 different changes that of a smaller scale that I'm not going to take everybody into at this time, but certainly would be happy to discuss with people on an individual level. Now, one of the things that I'm getting, and I'm happy to open it up to questions for, quite frankly, anything that anybody wants, but one of the in part of my practice in reviewing construction contracts and just dealing with, and this is just me talking generally about the industry that I'm seeing in the I'll call it the corridor, which is my client base from Oshawa through to Cornwall, is just the increasingly difficult, and this isn't a legal thing, but it's something to be dealt with timing and things that I'm changing in contracts because of it. The increasingly difficult contradiction, if you will, with respect to the increasing costs of materials, increasing cost of labor, decreasing availability of that labor talent, increasing interest rates, and the general flex in the industry where there's lots of work and not a lot of people to do it, and the increasing cost of money. It's amazing to me how everybody is on the fly adapting to all of these things, and it's starting to get reflected into our contracts that we're drafting with respect to delay costs with respect to contracts and builds and financing that we're doing, and delay in financing and all kinds of things. So I must say that, like, with respect to the people that I deal with in the industry and have been dealing with for the last 20 years, it's an incredibly unique and interesting time to be in this industry. And the changes that are being proposed are multifaceted and really going to have interesting effects on the industry. So in any event, that's just my little diatribe there. But I just wanted to say that. So I'm happy to, I don't know if people want to flip live as a participant, or if you want to type in your questions, or I'm happy to answer or have Phil answer or Chelsea if it's construction based, any questions that anybody might have.
Todd, we do have some questions in the Q&A. Well, there's one question in the
Oh,
Q&A. I
sorry, I
can read
missed
it
that.
out. I can read it out for you. Are municipalities operating under a development permit, community planning permit system exempt from the changes made to the zoning and site plan sections of the Planning Act?
Sorry, I'm just reading it
Yep.
myself.
Yeah, so
Go
I'll,
ahead.
I'll field that one. It's a good question, and I think it will depend on which provision specifically you're speaking about. So a development permit bylaw is operating under regulation under the Planning Act, and the regulation specifies that it is deemed to be a bylaw under Section 34. So unless there's a specific power to regulate something through a development permit system that's set out in the regulation, it's otherwise captured by the regulation that generally applies to zoning bylaws. So with respect, for example, to the ability to regulate up to 3 residential units, no, there's no exemption. So that is Section 35(1) of the Planning Act says a bylaw passed under Section 34 is deemed to be of no effect with respect to the 2nd and 3rd unit. So there would be no exemption there. With respect, for example, to the ability to regulate external aesthetics of a building through site plan control, yes, I think a development permit system could still regulate that because it derives its authority from the regulation itself and not from Section 41.
Okay. No other questions? We have a whole seminar on how to get your money paid, something like that. Anything under Construction Act, how to do liens, anything. No, just a thank you. I don't know. Is there any? I don't see any other questions, Ruth. If
No, I don't see any other questions. Can we talk a little bit about some of the specific examples that we discussed previously? Maybe there's an opportunity for people to chime in with additional questions if we get into those examples.
sure. Sorry. Specify for me. I'm at a loss to remember.
That's okay. So for example, development charges that were implemented in the city of Belleville, under the new regulations, what is the impact for our developers if those development charges were implemented in January of 2022?
Yeah. Do you have any thoughts on that, Phil? I mean, like I know in the Ottawa region on those development charges on the bylaws that have been implemented there and locally, we've been contemplating. I can tell everybody that, well, it's actually public record now. I'm challenging some of those development charges and bylaw charges on behalf of the Home Builders Association, and having a discussion with some municipalities about their ability to do that, specifically Ottawa. And were that to be successful, there's going to be changes to those bylaws because they could be deemed unenforceable. So how it's being played out locally on through the corridor, I know there's been some confusion. Well, I can only speak about the ones I know about, but I know there's been some confusion locally and confusion in Ottawa and confusion. I've had some discussions in Peterborough as well. So how they're going to ultimately play out though is going to be interesting as to whether they're going to affect development. I think they will in short term, but I also think, and Phil, correct me if I'm wrong, I also think that some of the municipalities are delaying implementation, right?
Yeah, so the trick with this is any new DC bylaw that's passed after January 2022 is subject to that 20% discount right off the bat, and that's phased in over the course of 5 years. Any existing DC bylaw, you can continue to operate kind of in full force and charge the full rate for. The problem this is going to pose, though, is that DCs aren't just revenue to the municipality, but they're going into reserve fund to fund infrastructure that's being shared back with, in most cases, developers who are front-ending the work that it's being collected for. And so part of the problem I think we're going to see with it is one, a lot of infrastructure is going to be delayed coming online just because the funds aren't there for it, and that will ultimately hold up some projects. And two, I think a lot of members would be concerned, especially if you're doing greenfield development or subdivision work, where you're front-ending major infrastructure projects that are DC eligible, that there may not be revenue coming in to pay you back for them. So I know there have been promises from the province that they will make municipalities whole on that front. Still unclear, as far as I know, how that will happen or how that shortfall will be made up. Something to be mindful of as a developer is, to make sure that those aren't being conditioned on you as a condition of subdivision for example, citywide infrastructure that your project is relying on, but isn't fully attributable to your community. So yeah, I think this is still kind of a work in progress province-wide, and I frankly don't know what the answer is.
And I haven't seen any, to your point, Bill, because I was looking over the weekend for someone else. I don't see any proposals on how there'd be I don't know how to term it, reimbursement. That's probably the wrong word, but I don't actually, other than a promise that it will be dealt with, I haven't actually seen even a proposal as to how it would be dealt with, unless you've seen something I haven't.
Yeah, and no, I haven't seen anything specific on how the province will deal with it. It wouldn't surprise me if we saw another round of legislation, following on the tails of Bill 97 as another cleanup bill to deal with some of these implementation issues. And I think in a lot of cases it will be dealt with kind of on a case-by-case basis. Maybe some developers are willing to take a bigger portion of that loss for the sake of moving forward on the application, or maybe it will just go to the tribunal and it will be a subject of further litigation.
We currently in Haliburton do not have development charges in place. Do any of these legislations sort of have any impact on that, as we hear rattlings that the county's thinking about moving forward with that?
Nothing comes to mind. I mean, there's no requirement to impose development charges, and there certainly are other mechanisms you can deal with. For instance, I'm at a loss for words, but a site-specific, area-specific tax under the Municipal Act would be another way to fund it. But no, these changes deal specifically with a bylaw passed under the DC Act.
Okay.
And here's Michael from the group's got a question. Says, we are struggling with the Conservation Authority demanding additional engineering on slopes and proximity to shorelines, etc. They are not accepting previously approved slope studies with buildable areas and asking to get professional comment on the specific house being built. They are also getting heavily involved on their expanded zones. Seems like we cannot find a rural property that they do not hold up for weeks and thousands of dollars of engineering, and then they can disagree and ask for more. Looking for direction on how to navigate around this. Well, Michael, I'm not sure I can give you direction on how to navigate around it. I've got clients that are dealing with the same issues. I can tell you that it's very look, some developments and some municipalities are easier. They're not remotely close to being the same. Sometimes you can negotiate or convince them that what you have is sufficient, but I'm not going to tell you there's an easy solution to that problem. I have had people come back to me and we've had to get an updated report or expert opinion. I've fought a few and argued with them with respect to sufficient, and depending on the situation, had them cave's not the right word, but agree that we have done enough to satisfy the requirements. But I don't know how to give you advice on how to get around it. I don't know. Do you have anything else that can be of assistance there, Phil?
Yeah, no, I mean, I think it's going to be again, a case by case situation, and,
Yeah.
happy to chat more about it. I think, as I said, if it's issues on a planning application, where they're commenting, that's starting to move beyond what services they're entitled to provide as a conservation authority now. So they're no longer allowed to act as a commenting agency, for a municipality to impose additional conditions or requirements for development approval. But they are still a regulatory authority in their own right. And so to the extent that you're dealing with them as, the conservation authority, and you need a permission under the Conservation Authorities Act, you need to make sure that you comply with the regulation.
Yeah, you need it. I don't know. I there's no way for me to tell you, or Phil to tell you how to get I'm sure that's not how you're trying to phrase it, but there's no way to get around that is the answer to it.
I'd like to add something to that.
Sure.
Not
Go
any legal expertise, but I think it's an opportunity for you to reach out to your local home builders association and use that collective voice to help with the situation. If it's something that you're experiencing, maybe it's something also that other development is experiencing, and maybe we can add an element of support and influence in that area.
Can I ask, just this is more of a question. It's not really related to what we're talking to, but I rarely get this many people in the room to talk about the industry in general. Is my perception that things for everybody are still incredibly almost too busy, and there's still labor shortages on the ground, and it's still hard to get material? I mean, Ruth, you could probably have a better sense of it than I do on the day-to-day, just because I'm working on just projects, so I know what my projects look like. But industry wide, is that still the case, or are things getting better? Because I feel like, from my perspective on the builds that I'm working on, it's getting worse. But I don't know if it just happens to be the builds I'm working on or what, but I wanted to get a sense if anybody's got like a sense of what it's actually like on the ground for everybody.
Yeah, I dare say things are getting better. I think you're right that for the most part, there's so many changes and so many things coming forward that it's been difficult to navigate and understand for the municipalities as well, I'm sure. And in our relationships with them, we're trying to, get all of that information before our members and how things are going to be handled. But I think for the most part, things have definitely not gotten any better. And then when you throw in all the other things you discussed earlier, the rising costs and interest rates, it just makes it even more difficult.
Well, because we can talk about this offline between the two of us, but I still think there's utility in, the questions that I get with respect to the industry in general, and labor and contracts and getting paid. I still think there's some value in maybe, we should always update everybody on what's happening legislative, because it's a moving target right now. And the consultation process just ended this month on the PPS, for example. So there's going to be more changes and regulations, but we should also, if everybody's interested, Ruth, you and I can talk about it, but just having discussions with members about what their contracts look like and how to get paid. I know that sounds basic, but it's surprising to me, sort of industry wide, the difficulties that people are still having with those fundamentals. And I just, if any, Ruth, you and I can talk about it, excuse me, at a different time, but I still think there's values in having discussions with everybody, even on a big scale like this, if you want at some point, about those sort of just basic fundamentals of like industry fundamentals.
Agreed. I think that'd be great opportunity.
Is there any Happy to answer any other questions. Oh, there's somebody. Here we have, okay. Municipalities are from Angelo. Municipalities are requesting developers to front end a portion of the expansion cost for DC services. Can they enforce this method of financing? If the developer is unable to provide the funds, is the municipality obligated to install the DC services without the private funding? It's your wheelhouse, Phil.
Yeah, so I mean, if you're looking at an expansion area and the city is trying to enforce it as I suppose a condition of development that you front end the services and then you'd be repaid through DCs as they're collected. So I guess to answer the question directly, no, I don't think there's any mechanism they can use to enforce that manner of financing, but it is an appropriate condition of development that you have the services you require. So if the developer is not prepared to or able to front end the services, I think you'll generally end up in a position of just waiting for that project to come online through the otherwise DC funded process. So you're kind of in a tough spot of, you know, do you want to wait for those services to otherwise be constructed and installed so that you can take advantage of them and move forward with your proposal, you know, or are you willing to front end them so that you can move ahead on your own timelines?
All right. Yeah, I don't.
Sorry, go ahead, Todd.
No, I was gonna say, I think that covers that one. And I don't see any other Q&As. So I'm in your hands, Glenn or John.
Well, if there isn't any further questions, we would like to obviously thank the panel for their time today. Much appreciated. And the the ability to access you guys possibly for other issues that we have, contract problems, those types of things in the future is huge. We will exploit that. Thank you. Like to also thank our sponsors once again, Cambium, pardon me, Consulting and Engineering, Three Hills Engineering Limited, and the recording today will be Ruth will be circulating this to the individual HBAEOs. So if there's members that wish to take a look at it, that will be available. That's basically a wrap, folks. Thanks very much. Ruth, did I miss anything?
Sorry, couldn't get myself unmuted there.
Yeah,
No, I
there you
don't
go.
think so. I think you covered everything. Thank you so much to all of our panelists for all the information today. Greatly appreciate it.
Yeah.
All right. Thanks a lot for having us, everybody.
And thanks again to all the attendees. I hope you all have a good week. Thanks.
Thank you.
Thanks.
Good one.